Good morning to all of you. Welcome to Legal Matters by Sai Babu Sankara. In this video, once again we are going to discuss the anticipatory bail law. So this is judgment given by the Honorable Supreme Court of India, two judges bench, Justice B.R. Gawai and Madam M. Nagaratna. So this bench, in the case of Tarun Aggarwal versus Union of India 2022 in SLP criminal number 7677 by 2022 dated 11/10/2022 held that if any conditions like ordering the anticipatory bail up to the framing charge, like that, if any conditions are there, they should be specifically mentioned, and the certain reasons which are necessary for that, they have to be made a part of the so-called resolution or order. Simply saying that till so-and-so date this man is granted anticipatory bail, it is not correct as per the observation of the Honorable Supreme Court of India. Right? You all know, suppose if any case is registered, the two non-viable case is registered, and you apprehend that you may be arrested, definitely you can file an application under section 438 CRPC for anticipatory bail. It is also called as pre-arrest bail. Right. So when you file the so-called bail, normally court may grant it, court may refuse it, court will grant it with certain conditions. So those conditions we have seen normally. So anticipatory bail is granted till the date of charge sheet. Anticipatory bail is granted till the framing of charges. Till such time he should not leave India, he should surrender his passport, he should not threaten the witnesses, he should cooperate with the investigation, he should not influence the witnesses. All these conditions will be there. Right? Whenever you give such conditions, you have to give the reasons also. That's why a reasoned order, reasoned decision should be there, particularly in law. Right. So here what happened is this Tarun Aggarwal is actually involved in a non-bailable case. So therefore he obtained anticipatory bail. So while granting bail, Allahabad High Court clearly held that, please remember, the anticipatory bail will be in force till the framing of charges. So later he is a free person. Right. So if such a case, if such an order is given, it should contain reasons as to why the bail should be continued up to the framing of charges. But this was not there in the particular order. So whatever it is, so when the matter, so the Allahabad High Court has given that order that the charge till the framing of the charge, the accused is granted anticipatory bail, but he wanted an early stage. So therefore he filed an SLP before the Supreme Court against the orders of the Allahabad High Court in view of the peculiar facts and circumstances warranted in his case. Right. Now the Allahabad High Court has given the bail order with that conditional bail order on 25/5/2022 in the month of May. Right. Now, when the matter came up before the Supreme Court, Additional Solicitor General, his name is Nataraj. So Advocate Nataraj, he stated that basing on the facts and circumstances, yes, definitely the court can limit the time of the anticipatory bail up to the framing of charges, up to the filing of charge sheet, like that. And he has filed a very good case law. This is Nathu Singh versus State of UP and others, 2021. Please remember this case. Nathu Singh versus State of UP and others, 2021. Of course, the Advocate General sought some more time to file the counter affidavit as to why the conditions were imposed, because he has to get the information from the High Court. So while things stood like that, Supreme Court clearly stated that they do not want to go into the reply affidavit of the government. Only thing is, what they want to say is, if any such order is given, they should mention the reasons as to why the order is given limiting the anticipated bail up to the framing of charges. But a perusal of the order given by the Honorable High Court of Calcutta reveals that there is no discussion at all with regards to the condition after which the anticipated bail is. Why this anticipated bail is limited? So please remember, it reflects the mind of the judge as to what were the peculiar facts and circumstances which warranted him to go to the limitation of the anticipated bail. So therefore, please remember, we don't want reply and other things. We are quashing. The orders of giving anticipated bail or limiting the anticipated up to the framing charges is quashed. That means he is set at liberty. He is granted anticipated bail totally. Very good judgment. Please remember these two case laws. One is Tarun Aggarwal versus Union of India 2022, the case which we have discussed. And reliance is placed on Nath Singh versus State of UP and others 2021. If you know these two cases, definitely it will be useful for your legal career. With this, I am concluding. Thank you very much.